You do.
All right, Senator, floor is yours, Senator Whitehouse.
Thank you. Judge Wilson, welcome to the Judiciary Committee. I have in these proceedings what I call the roving room rule, which is that all of the nominees come to us with a certain amount of history, opinion, political background, previous communications, and you look at that with a view to whether it signals that the individual will be able to leave whatever their politics and prejudices are, as previously expressed, in the robing room. And that when they get out on the bench in their robes, they will have all of that behind them. I hope you think that that's a fair standard.
Well, Senator, certainly since joining the Court of Appeals over a year ago, I have left policymaking and the political side of my background and experience, those other roles, left those behind and endeavored to decide every case fairly, impartially, according to the law and the applicable precedent.
What concerns me is in a lot of your communications, the tone is one of such bitterness and scorn towards Democrats, whether it's Attorney General Holder or President Obama or Secretary of State Clinton, that it makes it hard for me to believe that you can actually leave that bitterness and scorn behind you in the robing room. There's a question of sort of degree of vitriol and of unpleasantness about it that makes me wonder here. Is there anything you'd like to say to that observation?
Well, Senator, first, I think things said in the heat of campaigns, in political campaigns, would be more appropriate in policymaking, political, partisan politics. All those comments that you reference in terms of my writings came at a time before I was ever a judge. And the role is distinct, it's very different, and my personal views, political views of things have no place in deciding the cases that come before the court.
So let me ask you about something specific that you said with respect to Attorney General Holder. You said that Attorney General Holder, and I'm quoting you here, whined that voter ID laws are part of an illegitimate orchestrated effort by Republicans to suppress poor and minority voting. How do you know that voter ID laws are not part of an illegitimate orchestrated effort by Republicans to suppress poor and minority voting?
Well, Senator, as a sitting judge, I don't want to comment on political issues or issues that may be litigated before the court. Well, to respond to your question, though, I can offer the experience I had in the Secretary of State's office as well as during my private practice years. The sanctity of the ballot is very important to me. In fact, I look at the right to vote as, I think it's been referred as the preservative of all the other rights. Vitally important. And I've spent years over my career in public service and otherwise working to protect both the integrity of the ballot as well as to expand access to voters, to the voting process.
So the Fourth Circuit, U.S. Court of Appeals, looked at a North Carolina voter suppression scheme, for want of a better word, and it made the following finding. I'm reading here. The new provisions target African Americans with almost surgical precision. So that finding would clearly seem to meet the standard that it is an effort to suppress poor and minority voting. And the North Carolina decision in the Fourth Circuit also went on to say that North Carolina's asserted justifications cannot and do not conceal the state's true motivation, close quote. So clearly they were dissembling to the court to cover up their purpose, which would seem to be me to qualify as part of an illegitimate and orchestrated effort. So when you condemned a notion that voter ID laws could be part of an illegitimate orchestrated effort to suppress poor and minority voting, were you aware of that decision? Were you aware of these voter practices that have been over and over again called out by federal courts?
Well, Senator, again, speaking from my experience in Mississippi, I was more familiar with our voter ID law that was enacted by popular initiative by a pretty substantial margin, I think 62%. That law provided safeguards for voters who didn't have an ID, for example, to obtain one for no charge. It also provided safeguards for voters who didn't happen to have their identification with them when they went to vote at the polls. It was based, if I recall, on the law from Indiana that was upheld by the United States Supreme Court. Certainly, the experience with Mississippi's voter ID law is far different than what you described in the Fourth Circuit case, in that it was implemented without objection from the Obama Justice Department and without litigation, as far as I'm aware.
Well, I'm over my time, so I'll conclude. But you didn't say that Mississippi's voter ID laws were the subject of your comment. You talked about voter ID laws in general. So I hope, well, I would feel pretty bad if I were coming in to challenge a voter ID law before a judge who had made such a blanket statement as this. And I hope you have the opportunity to correct it before this is concluded. My time has gone over too far, Mr. Chairman. I appreciate your courtesy.
Thank you, Senator Whitehouse.